has not made me a lot of fans out in the state bar community, but and that's fine. You know, I'll take my lumps. They're my friends.
Oh, really?
Basically, it introduces a new concept, which is basically bringing in an impartial fact finding. Effectively, they call it a disciplinary commission. Effectively, be a jury that would sit on these issues involving attorney discipline. The concern, and I'm trying to summarize what is a lot of testimony down in just a moment, is this idea that the bar will both bring charges and then serve as both the judge and jury in terms of the fact-finding inquiry. And I have a long list of witnesses, and I know we don't have time, but I think let me just take them in order. I have Leslie Haley, who is a 14-year member of the state bar and senior assistant ethics counsel, and is currently on the Chesterfield County Board of Supervisors as my number one witness, if you could call her up. She's either here or on Zoom. What's her name again? Leslie Haley.
Leslie Haley, are you out there in the Zoom world? Leslie Haley?
Mr. Chair, Leslie Haley is not on the Zoom.
Okay, 0 for 1. Let's go with Victoria.
That's a good start.
Okay. All right. I also have Victoria Pearson.
Is she in the Zoom?
I don't-
Victoria
who's-
Pearson.
Why don't we just tell me who's on Zoom? Maybe that's easy.
Victoria Pearson.
Victoria Pearson is not on the Zoom.
All right. Why don't you tell me who is in the queue?
Mr. Chair, Senator Peterson, there are 49 people on the Zoom. Would you like me to say each name?
All right. All right. Okay. I have a list of 8 witnesses, and they're not under subpoena, so I can't verify they're here. I also have James Whitener.
James Whitener is on the Zoom, Mr. Chair and
So
Senator
let's have
Peterson.
James Whitener then. Yep.
We can discuss people with it.
Mr. Chair, if you just give me one moment.
Okay. 5 minutes total on
Yep.
witnesses.
Mr. Chair, James Whitener is in the Zoom room now.
Okay, Mr. Whitener, let's have it.
James Whitener, would you please unmute? James Whitener, would you please unmute?
Mr. Whitener, going. One.
Can you hear me now? Hello?
Yes, we can hear you, sir.
Okay, thank you very much. Hello, Mr. Chairman and Senators. My name is James Whitener. I'm a native Virginian, born and raised in Portsmouth, and I currently reside in Blacksburg. For 28 years, I was a special agent with the Naval Criminal Investigative Service, specializing in major fraud, white-collar crime, and foreign counterintelligence. A few years after retiring from NCIS, I was employed for 4.5 years as an investigator for the Virginia State Bar. I resigned from the Virginia State Bar in part because of the Virginia State Bar's selective enforcement, favoritism to certain lawyers and law firms, and inherent corruption at the VSB. I'm sure many of you are aware of the dubious history of the Virginia State Bar and its efforts to use ethics rules to suppress NAACP lawyers in their fight against massive resistance, as noted in the U.S. Supreme Court opinion in versus Burton in 1963. I was not aware of this dubious history when I began working for the bar, but I came to recognize during my tenure that the bar orchestrated favoritism to certain lawyers and improper punishment of attorneys who dared to zealously defend their clients and challenge the bar in its improper application of its regulatory function. The proposed legislation is a good first step to wrest power from an elite group of lawyers who use the bar as a cudgel against opponents and as a shroud of protection to hide their own crimes and indiscretions. During my tenure with the bar, I watched as they practiced at a minimum selective enforcement, but in reality was a perverse corruption of the legal ethics mission of the VSB, which is to protect the public. It is only in the past few years I have learned of J. Lark's 1995 report describing the inherent conflict of interest under which the VSB operates. They have assumed powers not given to them by the legislature, and use these assumed powers to punish and sanction sole practitioners, small firms, minorities, and women. Again, this proposed legislation is a good first step to ending their quiet reign of terror. I have watched as bar councils have allowed the raping and pillaging of the states.
Let's just move on to the other people.
Yeah, thank you very much. You have, who else you want to
Could
call?
I, do Retta Daniel?
Retta Daniel. Retta Daniel here.
Retta Daniel is here, Mr. Chair, and Senator Peterson.
Okay.
Go ahead. Ms. Daniel, can you do it in 1 minute?
I don't know how to turn on
Mr. Chair, if
my,
you just give me 1 moment while.
I'm trying to do it.
Retta Daniels, would you please unmute?
I'm trying to figure out how to do that.
Retta Daniels, would you please unmute?
If I could see how. Oh,
It looks like Retta Daniels unable to unmute.
no, I can unmute. Just tell me how. There.
Mr. Chair, Retta Daniels is in the Zoom room, but she is not.
Now,
unmuted.
I've unmuted.
Okay, go
I had
ahead.
to find the place to do it.
Can you do it in 1 minute, please?
Sir,
Yeah, go ahead and give you 1 minute.
1 minute.
Yeah.
Well, that's really nice. I have probably more experience with the Virginia State Bar than anyone in your room. I came out of law school in 1977. I went to work for the bar in 1982. I was immediately told to cover up a sexual predator and a cocaine user who was taking cocaine from his client and payment of fee, and the other one was taking sex for payment of his client's fee from the client's wife and wanted a twosome. They were both criminally convicted. Since then, since 1982, I have actively tried to fight the corruption of the Virginia State Bar. That's 36 years now. And I have been a victim of the bar as well, because I was outspoken about their corruption. I have statistics that show what Mr. Whitener just said, that they pick on women, minorities, sole practitioners, and small firm members. And I've got those statistics from the bar. Mr. Whitener has them as well. And therefore, they came after me in 2018. They tried to say that I was impaired to practice law, which I was not proven to be impaired to practice law. So then they suspended me for not giving them 5 years of medical records from all my providers and going to their psychiatrist for an independent medical, as they said it. But I had psychiatrists' expert witness reports that said I was not impaired to practice law. Following that didn't satisfy them. I was suspended.
Your time is up. I'm sorry. I think we get the point.
I think it's important that I finish, sir. I have more experience than anybody in that room.
All right. Okay. Thank you very much. We appreciate it. Chap, who else you got? Is Tony Jackson here?
Mr. Chair, Tony Jackson is not. Oh, he is. Jackman? Tony Jackman?
Can you do it in 1 minute?
Jackson, I think, Tony Jackson.
Tony Jackson is not in the Zoom room.
Okay. Who else you got, Chap?
Okay, the other one I have is Jason Anthony, and I'm going to stop there.
Jason who?
Anthony.
Jason Anthony. Is there Jason Anthony?
Oh, that's right.
No, I think it's important as a victim of that to be able to speak. And as I watch all of those laugh at people.
Chap, do you have another speaker? Somebody wants to, she wants to speak. Does she want to speak, Chap? Right there.
Oh, okay.
Would you, if you're in favor of the bill, go ahead, come. All right, stand up and speak, okay.
I'm in favor of the bill.
Okay, thank you very much. Come up and speak.
Okay, thank you very much.
All right,
Mr.
and what's your
Evans.
name?
My name's Janice Walt Grenadier, and I've filed several complaints with
And
the
where
bar.
are you from?
I'm from the city of Alexandria,
Okay,
Virginia.
but you're not a lawyer, or are you?
No, I'm not a lawyer.
Okay,
I have handled my cases pro se, and I've stand in front of you all before and been laughed at. And I find it extremely disgusting. The bar and the jerk both
We'll give you,
have violated so
we'll
many
give you
people's
30
rules.
seconds, okay? Go,
Thank you
we've heard
very
you
much.
before.
So for my experience is that the Virginia State Bar, the ethics guru, Mr. McCauley, said he wouldn't meet me in Richmond. He would only meet me in a bar in Arlington. And then he had me mail all of my information regarding the fact that lawyer Alona Grenadier Heckman was stealing out of a trust fund for Sonia
Yeah,
Grenadier.
okay.
the mother
Listen,
of
I
Judge
think
Albert
we've heard
Grenadier.
enough. That's enough. Thank, Chap, you have
So we
anybody
do
else?
need change, and I appreciate it.
Nobody, Chap has nobody else. Anybody would like to speak against the bill?
Yes, sir.
Jay?
Thank you, Mr. Chairman. I want to thank the committee for providing the Virginia State Bar with the opportunity to be heard on this important matter pertaining to the regulation of Virginia's lawyers. And Chap, as an old friend, I should say, Senator Peterson, do not fear, you will continue to be a friend of mine. My name is Jay Myerson. I am the president of the Virginia State Bar. And on behalf of our over 30,000 members and the VSB Council, I address the committee to voice the VSB's firm opposition to this bill. We oppose 561 because it will, number one, uproot hundreds of years of self-regulation of the profession at great cost to create the first in the nation legislative attorney disciplinary commission based on what we would submit is little discernible rationale. Number two, provide less protection to the public from lawyer misconduct. And number three, provide less transparency with at least the appearance of potential political considerations in decision-making, thus undermining Virginians' confidence in the lawyer disciplinary system and profession. Let me underscore, this disruption would occur with little discernible rationale despite the stories we just heard, the proverbial solution in search of a problem. It is important to note that my remarks today reflect not only the position of the VSB, but I can represent that the Virginia Bar Association, the Virginia Trial Lawyers Association, the Virginia Women's Attorneys Association, the Old Dominion Bar Association, and the Virginia Association of Defense Attorneys all oppose this bill. You have been provided with copies of a uniform letter signed by the presidents of each of those organizations. They're with you right now. Additionally, you have a list of former VSB presidents, who are all of them living, and they're the ones that we still have who are not judicial officers, all of whom are in opposition to this bill. Moreover, it is worth noting that the VSB is completely unaware of any concerted opposition to the lawyer discipline system as currently constructed. Some have argued that the disciplinary system is tilted in favor of bar counsel over accused lawyers, or that the disciplinary system favors bar counsel. Several facts dispel this contention. Facts are difficult things and ornery things. They just sort of hang out there. First, in fiscal year 21, for example, 81% of complaints were dismissed without reaching the investigative stage and often without the accused lawyer's knowledge. Of those remaining, only 5% of the complaints received resulted in the imposition of a public sanction. Consequently, the overwhelming majority of lawyer complaints are perfunctorily dismissed or addressed privately, usually because the allegations fail to allege an ethical violation. As to allegations of coziness between bar counsel and the disciplinary board, every accused lawyer has the option to choose a 3-judge circuit judge panel in lieu of the volunteer members of the disciplinary board. Yet over the past 5 years, by an average of a 4-to-1 margin, accused lawyers have opted to have their cases heard by the disciplinary board. Furthermore, over the same 5-year period, the disciplinary board was just as likely to dismiss the charges against the accused lawyer as were the judicial panels. There are advocates for change. If the advocates for change to the lawyer disciplinary system, if they truly wish to seek reform, we encourage constructive criticism through identification of specific instances of apparent shortcomings. The VSB Standing Committee on Lawyer Discipline is an appropriate starting point. Its meetings are accessible to the public. Its members are of open mind and good faith. They're both attorneys and lay people. The VSB regularly revisits and, as appropriate, recommends changes to the procedures to the Virginia Supreme Court, which is ultimately the final decision maker on the disciplinary rules. As recently as last summer, respondent conscious revisions were recommended and adopted by the Virginia Supreme Court. In conclusion, the bar respectfully asked the committee to reject this bill and its radical and unprecedented departure from vesting lawyer discipline in the judiciary and from Virginia's long-standing practice of permitting professions to engage in self-regulation. Thank you.
Thank you. Anybody else against the bill? Yeah. Go
Mr.
ahead.
Chairman, members
Yeah.
of the committee, Alyssa Padden with the Office of the Executive Secretary. The court system opposes the bill for the reasons already stated by Mr.
Supreme Court
Myerson.
opposed the bill. Okay. Yeah.
Mr. Chairman, Jeff Palmer on behalf of the Virginia Bar Association. I would, in addition to the comments by Mr. Myerson, I would add that the legislative branch is vested with legislative powers, and I don't believe that oversight of a profession would fall within legislative powers that the General Assembly is.
Am
under
I
the
correct
Constitution.
that we have a tradition in Virginia that professions govern professions? Doctors govern doctors, nurses govern nurses, lawyers govern lawyers, right?
Pursuant to the requirements that have been set out by the Supreme Court, yes.
Okay.
No, you're
Thanks.
wrong.
Next.
Mr. Chairman, Reese Wilkes on behalf of the Virginia Creditors Bar Association, which is made up of attorneys barred in Virginia. We join in the opposition. Thank you.
Thank you. Okay. Does anybody else want to speak against the bill? All right, Chap, you have anything else you want to say?
Well, I think it's unprecedented. I've been able to bring these organizations together, so I just leave it at that.
You're a good lawyer. Brought them all together.
Not easy. Wasn't easy.
Okay. Is there a motion? Is there a second? All in favor of the motion to pass the bill by indefinitely? All in favor vote aye. All opposed vote no.
Mr. Chair, I actually have the wrong bill up. I hit the wrong button. Pardon me.
Okay. We're gonna redo this? Okay. Pass the
Yes, sir,
bill
Mr.
by
Chair.
indefinitely. Vote aye if you're in favor of passing it by indefinitely. Vote no if you want to. Yeah, it's still on the board. Which?
Yes, sir. Senator Norman, Senator Deeds,
Okay, just a minute.
ayes 12, noes 3.